There are specific powers that the court has to order the key terms of a renewal lease where they are disputed. These are things like the extent of the premises, the length of the renewal term, and the rent that is to be payable under the renewal lease. In terms of the extent of the premises, in most cases the court must order a new lease of the holding, which is the whole of the property, but excluding any part that is not occupied by the tenant for the purposes of its business. The landlord does, however, have the ability to insist that the court grants a new tenancy for the whole of the property as it was let by the original lease. If the landlord insists, the court has no discretion to do otherwise. This can put the tenant in a difficult position if it does not want to take a lease of the whole of the property and take on continuing liability for that extent, as it is left with only one option: to decline the renewal. In reality, this is only likely to cause difficulties for tenants who have taken on leases of larger properties. If the landlord is opposed to the grant of a renewal lease on grounds of redevelopment, the court may order the grant of a new lease of less than the holding if it forms an economically separable part. As to the length of term of renewal lease, the maximum term that the court has discretion to order is 15 years. Subject to this upper limit, the court has a very wide discretion and would take into account matters such as the length of the original tenancy, the period of the time that the tenant has already been holding over, current market practice, and the respective reasons of the landlord and tenant for the length of term that they have each requested. Where, for example, the landlord is able to convince the court that there is a realistic prospect of redevelopment of the property taking course over the life of the renewal lease, the court will bear that in mind when considering the length of the lease term and may, for example, include a landlord break for redevelopment. For tenant break clauses, the court will usually carry forward a rolling tenant break into a renewal lease unless the landlord can provide justification with good reasons that it should not do so. Other breaks, for example those exercisable on specific dates, so 24th of September 2015, may not necessarily be carried forward into the renewal. As to the rent, it won't surprise you to hear that this is the question that is disputed the most. The court will base its decision on expert evidence provided by each party's valuers. The court will have regard to all of the terms of the renewal tenancy when assessing the amount of rent that is to be payable under it. Accordingly, it's usually one of the last things to be agreed. The court doesn't have any discretion and must decide the rent as a matter of valuation on the basis of the annual open market rent payable at the probable date of commencement of the renewal lease term. The court does have discretion, however, to include a rent review clause in the renewal on such frequency and basis as it sees fit. It is open to the tenant to try to persuade the court to make provision for an upwards-downwards rent review if it thinks there might be any merit in trying to do so. In fixing most other terms of the lease, the court will have regard to all of the relevant circumstances and will look to the terms of the existing lease as a starting point. Accordingly, the court's discretion is wide, but is directed by a number of guiding principles. The first of these is that if one of the parties is seeking to change the terms, it is for that party to justify it with good reasons that are fair and reasonable. If there is a benefit for one party, the court will consider whether an adjustment to the rent ought to be made to compensate the other for the result. The court should take into account, however, the comparatively weak negotiating position of the tenant in a renewal application. The other thing that the court will bear in mind is the overriding function of the Act, which is to provide a tenant with security of tenure of its premises for the purposes of carrying on its business. The court's discretion includes the ability to determine whether or not the tenant should provide any guarantors. Just because when a lease was originally granted, a tenant provided a guarantor, it doesn't necessarily mean that the tenant will be obliged to do so again on a renewal. Again, it's something for the court to determine what is fair and reasonable at the point at which the renewal lease is being entered into. Following service of either a Section 25 notice or a Section 25 request, while the renewal lease terms are in the course of being negotiated by agreement or by determination by application to the court, either party can make an application to the court for an interim rent. An interim rent is an amount of rent that is payable before the renewal lease is granted. Typically, interim rent applications are made by landlords where they think that the interim rent will be substantially higher than the existing rent payable under the continuation tenancy. That may have been fixed many years before, say 5 or 10 years previously. Tenant applications are far less common, but they can happen where, for example, premises are over-rented in a falling market. For an unopposed new tenancy of whole, the general rule is that the interim rent will be the equivalent to that which would be payable under a renewal lease.